Okay. Oh, I was going to put something on the board. Too late. I'll just do this orally, and you can jot it down in your notes. Also, I've been told that when I write things in chalk on the board, it's not that easy to see anyway. So, back up a little. We're starting to get some clarity. And if I were you, I would probably be a little resentful right now. Why couldn't you just give us this clarity at the beginning? And it's a valid point. The historical approach that we're taking traces the way things develop. I know where it's ending, and the benefit, of course, is you see where it all comes from. The downside is it takes a while for the picture to become clear, but we're starting to really get there. So consider the following. First we had, let's call them 1791 rights. The rights that were secured by the Constitution as ratified after the Bill of Rights is ratified in 1791. Those were rights contained only in the Constitution itself, obviously, right? And basically they applied only to the federal government. That wasn't completely true. Fletcher versus Peck, right? The Contracts Clause, or Calder versus Bull, the ex post facto clause, Article 1, Section 10, has a very limited set of restrictions that apply to the states that can be asserted as rights. But by and large, what I'm going to call 1791 rights only apply to the federal government. And that was true right up until Reconstruction. Enter the 13th, 14th, and 15th Amendments, and we now have, in addition to the very few, to the property rights secured, and only property rights, secured in Article 1, Section 10, we now start to get discussions of other rights. Initially having to do with the 13th Amendment and Congress's power under the 13th Amendment to abolish slavery and its vestiges, its badges and incidents, as Lyman Trumbull put it. And Congress launches eagerly into that and is smacked down by the courts, right, in the Slaughterhouse and Cruikshank and that whole set of cases for about 20 years. Then comes the Lochner era. In the Lochner era, we see something new. Substantive due process. The idea that the term liberty and the term due process in the Due Process Clause, taken together, create a set of rights that apply against the states. So now we have two sources of rights. We have 1791 rights that basically apply to the federal government, with those very few exceptions. And we have 14th Amendment substantive due process rights. And thus far, we have seen those only in terms of economic rights. So far, so good? It's all familiar? The rehashing of last time? All right. Today, we're going to add the next piece. And it's really the last piece. I mean, these are really, this completes the picture in terms of what are the sources of rights. Although it doesn't obviously begin to end the discussion of what are their limits, what do they mean, what are their scope, and so on and so on. The piece that we're going to add today is called incorporation. Incorporation is the idea that microphone is on, yeah? Something about this room I can never tell, thank you. Incorporation is the idea that you heard expressed by Bingham, that the adoption of the 14th Amendment means that the Bill of Rights applies to the states. Now, as with everything else, it's more complicated than that. Is it the case that the Bill of Rights applies to the states? Some of the rights in the Bill of Rights apply to the states? Rights in the Bill of Rights, but no other rights apply to the states? Some of both, right? Lots of different ways to slice this cake, or whatever metaphors, or skin is, stick with that one. But we are going to see today the introduction of the third concept, incorporation. So going forward, it is not perfectly true, but covers more than 90% of cases to say that rights either come from the 1791 Constitution or the 14th Amendment by substantive due process, or the 14th Amendment by incorporation. And the two 14th Amendment routes, those are the ones that create rights that can be asserted against the states. The 1791 rights can be asserted against the federal government. And I'm going to stop saying this, but just always remember, plus the very few things in Article 1, Section 10 that we saw in Fletcher versus Peck. And sometimes that we're completely done with the Contracts Clause. I'm just trying to map out the structure a little bit better, okay? So that's one thing we're going to see today. Another thing we're going to see today is that while it was absolutely true that during what the authors called the Republican era, or with slightly different years, what I'm calling the Lochner era. I would say the Lochner era goes from 1890 to 1937. They say the Republican era goes from 1870s, was it 7? To 1932. We're talking about roughly the same period of time, with differences as to where we start it and stop it, which is the kind of debate academics have, right? But in that period, let's call it from the turn of the century to the early 1930s, which will agree with that. In that period, it is true that the major concern of the courts in finding substantive due process rights had to do with economic rights. Holmes said, aha, this is just because they're a bunch of laissez-faire capitalists trying to impose, they like to benefit the rich and screw the poor because they're all laissez-faireists. And Holmes says our Constitution, remember his dissent in Lochner, our Constitution doesn't require this. I suggested to you that's not a good reading. I said laissez-faire is not a good description of what's going on. I pointed out there are numerous cases in which statutes were upheld, right? And that the logic that the courts relied upon, that Peckham relied on in Lochner, was rather more complicated than just to say you can never regulate economic behavior. What he did say was that there's never a justification for regulating economic behavior as such. That's that considered purely as a labor law line, remember? But it's perfectly acceptable, which is contrary to laissez-faire ideas, it's perfectly acceptable to regulate economic behavior in the process of, as a consequence of the exercise of police powers. And it's because of that tension that I suggested we think about this as balancing 14th Amendment rights against police powers. Again, I'll review. Again, I hope not too repetitive, but helpful rather than boring. It seems to me it's easy to lose track of this stuff when we start looking at it issue by issue and case by case. It's very easy to lose track of the larger picture of what's going on. Today's material, I will argue, and again, you never have to buy any argument that I make like this. I'm just hoping it helps you see what's going on and follow more clearly. But you don't have to accept any arguments. You just have to get them. So I'm going to argue that today's material further erodes Holmes' position. Further shows this was not simple laissez-faire capitalism. Something much more interesting and complicated was going on. Not only is it the case that the Lochner-era courts did not strike down all laws that had the effect of regulating economic activity, it's also not the case that economic rights were the only ones they cared about. It was the biggest issue. It was the biggest point of focus, no question. But it wasn't the whole thing. We're going to see something very, very different a very, very different form of substantive due process come out today. Okay, last point before we start digging into the material of today's lecture. It is my constant complaint, as you know, that the distinction between 411 and 412, between discussing rights and discussing powers, is artificial. And it causes us not to recognize points of connection that we might recognize better if we did this differently. If you're curious, the way I've always wanted to do this is to have one semester go up to the Civil War and one semester from the Civil War to, or perhaps World War I. The problem is there's no textbook that's organized that way, and writing, if you take a look at your book, you can see how much work goes into writing one of those textbooks. If there were one, I would use it. Although my suspicion is very few people would sign up for the early history one, and everybody would sign up for the second one. But anyway. The reason I'm saying all this right now is that from a political perspective, we usually think of the Lochner era not only, or even perhaps not so much, in terms of the fact that the courts were eagerly striking down state laws. And in your reading, there's a chart and some description about just how frequent it was, these overrulings were. And there's no question, these were very, very active courts, striking down laws at rates not seen before or since. It's not true they struck down all of them, but it's certainly true that they were very, very eager not to show deference, to use that key term. But it's also the period in which they're striking down federal laws under the Commerce Clause. There's an attempt to have a federal law against child labor, and it's ruled to be unconstitutional. There are attempts to have federal laws regulating other areas of work, and they're declared unconstitutional. There are attempts to use the Sherman Antitrust Act to break monopolies, and these are ruled unconstitutional. And in 411, if you have had that course, or if you take that course at some point, and it doesn't matter whether it's with me or someone else, you'll go through at some detail what these arguments were about, and they had to do with what's the reach of the Commerce Clause, what's interstate commerce, what are Congress's powers. But what connects them, it's the same justices, right? Often hearing these cases the same day, the same week, the same term. So it's not as though we have two different courts making these two decisions. And what connects them are a couple of things. One, a profound lack of deference. an eagerness to second-guess the Congress just as much as there's an eagerness to second-guess the state legislatures. Not only on legal questions, but on empirical questions. Is this really a monopoly? Right? Is this really a harmful practice? 2, an eagerness to use these rather formal legal principles to prevent innovation. So one of the things that we saw, I suggested anyway, in Lochner, and in comparison to Mueller, for example, Mueller versus Oregon and some of the other cases that we mentioned in passing, was that where traditional exercises of police powers were at issue, the courts were willing to let them go forward. Where people argued, oh, we have new novel circumstances, new economic circumstances, new social circumstances, whatever, therefore we need new exercises of police powers, is where the courts were most eager to step in. And the same goes for the federal government. Where the federal government was doing things that it had always done, it was no problem. It is not as though, it would be just false to say that the courts in this period tried to dissolve the federal government or disempower the federal government. What they wanted to prevent was change, the growth of the federal government into new areas and regulating things in new ways. And of course, the progressive counter-argument is, yeah, but you have massive change in the economy. You have corporations, which we never had before, some of which are the size of countries, which they never were before. We have industries that occupy whole cities. Doesn't that change things? And that was the debate, the political debate. All of this comes to an explosive confrontation with the Great Depression and the New Deal. Because the same court is the court, and the same philosophy, and the same arguments about class legislation, and the scope of police powers on the one hand, and the understanding of congressional powers to regulate commerce on the other, all of that same language by the same people is used to strike down the New Deal programs that the Roosevelt administration tries to put into place for its first 5 years, 1932 until 1937. We'll get to that next lecture. But my point is, these are not separate stories. This is all the same story. So when we're looking at rights in terms of, and this is how we often talk about rights in our system, right? Things courts will enforce to prevent states from doing things, or things courts will enforce to prevent the federal government from doing things because you're violating somebody's rights. The story about this court being, the modern word is activist, not deferring to legislatures, imposing a very specific legal theory, being resistant to novelty, whether it's about police powers or economic consequences or what's the public good. Right? That was my theory, it had to do with constructions of what can be the public good. But those sort of new ideas, that was resisted. All right, let's dig in. So we're going to start with a 1791 right asserted against the federal government. Right back to the very basics, the First Amendment, the freedom of religion. And the question is polygamy. Can the federal government prohibit, well, the federal government, first of all, banned polygamy in the territory that contains Utah. And then when Utah entered as a state, it was on the condition that they outlaw polygamy. Question. Under the free exercise of religion clause of the First Amendment, which applies directly to the federal government and has applied to the federal government since 1791, can they do that? And the answer is yes. This is 1878. All the other cases dated in the 1920s. We're doing this one because it's the first post-Civil War. It's actually the first case I know of in which the religion clause is asserted as a constitutional rights guarantee at all. So, Brigham Young, the leader of Utah, was certainly not shy about asserting his religious faith, as you would expect, and its relevance to his activity. If I am controlled by the Spirit Most High, I am king. This is a quotation of his that got bruited around a lot at that time, which President Hayes responded, the territory of Utah is virtually under theocratic government of the Mormon Church. The union of church and state is complete. Polygamy and every other evil sanctioned by the church is safe. To destroy the temporal power of the Mormon Church is the end in view. A couple things about that. And it's interesting to me to visit this 1878 case because of the way in which the issues that it involves are issues today as well, although, of course, the vocabulary is different and the analysis is somewhat different. But Hayes takes it as given that the First Amendment requires a separation of church and state. But the fact that there is a union of church and state, in his words, is clearly a problem. The goal, he says, is not to suppress the religious activities of the Church of Latter-day Saints, but to abolish their temporal power. In other words, to get the church out of the business of exercising any control over civil government. In 1878, that was not a contentious viewpoint. Actually, it wasn't a contentious viewpoint at all until about 2000. In the last 20 years, pretty much for the first time in our history, at the federal level, there's been an argument that the First Amendment is not properly understood to require this separation. And we'll get to that and see what the contours of the argument are and so on. In 1890, confronted by this decision in Reynolds versus the United States and the federal government's insistence that they give up polygamy, the Mormon Church announces that there's been a divine revelation which requires them to give up the practice of polygamy. That solves the problem, and Utah is able to enter as a state without any conflict. Had they not done that, or had that revelation not occurred, presumably this conflict would have continued and would have come to some sort of crisis. Right. Waite is the name of the justice who writes the opinion, and it's 9-0. And he starts with the idea of separation of church and state, more specifically, a wall of separation between church and state. He quotes Jefferson's letter to the Danbury Baptists. He doesn't mention that Jefferson actually stole the phrase from Roger Williams, a dissenting Puritan who left Massachusetts to found Rhode Island. The Puritans who founded Rhode Island were so offended by the mixture of church and state, they went around with cutting the cross symbol out of the flag of the state of Massachusetts. It was an act of vandalism. For those of you who went to Sunday school or religious school, Judeo-Christian religious school, the principle for Rhode Island was that the government had no business with the first table, meaning the first 5 of the commandments. Things like, thou shalt have no other God before me, and so on. Because those were matters of faith. It was a strict separationist theory, very different from Massachusetts or New Haven. Sometime we can talk about the great variations among different Puritan settlements. Puritanism wasn't one thing. There's a whole range of different things. So he quotes Jefferson. So the Danbury Baptist community had written a letter to Thomas Jefferson saying, you know, we're a little worried. Baptists were among the groups of Protestants who were looked down upon and often discriminated against by more respectable elements of the Protestant church, like Anglicans and Congregationalists, Anglicans in Virginia and Congregationalists in New England. And so they felt themselves to be, if not outright persecuted, certainly not made welcome, and concerned that they might, for example, be driven out of cities or something of that sort in the future. And Jefferson writes back, explaining his understanding of the role of the First Amendment in protecting them. I contemplate with sovereign reverence that act of the whole American people. Go back to our discussion of Federalists and Anti-Federalists, remember? Is it 13 states or one people? Here, Jefferson is speaking the language of one people. Jefferson used whatever language suited his purposes. You can find Jefferson using phrases that fit any number of different theories on these questions. It's one of the, depending on your position, charms or frustrations of quoting Jeffersonian texts. I contemplate, with sovereign reverence, the act of the whole American people which declared that their legislature should make no law respecting an establishment of religion, or prohibiting the free exercise thereof, right? So he says these two clauses together, thus building a wall between church and state. Readers at the time, by the way, would have recognized that as Roger Williams. They would have recognized that as a reference back to an extremely strict separation of church and state that insists on an absolutely solely secular government on the one hand and an absolutely untrammeled religious authority on the other. So the phrase would have had resonance. I shall see with sincere satisfaction the progress of those sentiments which tend to restore to man all his natural rights, convinced he has no natural right in opposition to his social duties. The underlining here, I'm sorry about that, that's underlining I put in once previously for a lecture and forgot to take out. But those are phrases that I think are terrifically important. So, three things about Jefferson's statement. One, he is obviously embracing the wall of separation between church and state. And to this day, when anybody uses that phrase, they cite this letter from Jefferson. They don't cite Roger Williams. Two, the idea there is no natural right in opposition to social duties. Jefferson entirely rejected the idea that there could be religious exemptions from civil laws. That being a religious believer could in any way mean that you were entitled not to follow a law that applied to everyone else on the grounds that it interfered with your faith. He accepted, embraced, whatever was the right word, believed in the idea that civil duties and what we owe to our faith are separate ideas. Madison felt the same, although he was a little more slippery on particular questions like militia service. It's worth remembering, how many of you know, I don't know how many of you know about, how many of you know what Jefferson's religious views were? Oh, so he declared several times that Christianity was a great lie that had been promulgated upon humanity that needed to be cured. He produced a version of the Bible, which he called the reasoned version of the Bible, which he took all the miracles out and all the references to God out. The name for his particular form of faith was deism. The idea that there is a grand intelligence creator in the universe, but that rejects any notion of any direct communication or understanding of any will from that entity. So he has all kinds of wonderfully radical, today they'd be offensive, Jefferson quotes about, I look forward to the day when the stark superstition that is called Christianity will be banished, et cetera, et cetera. Once he became president, he stopped talking that way, for understandable reasons. So the point is, citing Jefferson is a really clear gesture. It's really, in this context, it's pointing really clearly that we're going to justify what we're doing here. We're going to justify banning polygamy, despite the fact that before 1890, it's part of the religious teaching of the church, and we're going to justify it on the grounds that the two religion clauses taken together are all about starkly and strictly separating church and state. Justice Waite says, coming as this does from an acknowledged leader of the advocates of the measure, that is Jefferson, an advocate of the First Amendment, it may be accepted almost as an authoritative declaration of the scope and effect of the amendment thus secured. So a kind of originalism, this time not original, this is closer to the original intent. This is what, Jefferson's important, this is what he meant, therefore this is what we should do. And in this instance, originalism is being invoked, or a version of it anyway. I don't think he thinks he's bound by Jefferson, so much as that Jefferson is illuminative, guiding to this extremely, extremely strict separation of church and state, which he has to do. Why does he have to do it? Because polygamy was not a trivial element of Mormon religious practice. It was a Mormon right, right in the technical sense of the term. It was part of the rights of the church. And so to assert that the federal government had the authority to ban a practice that is a right of an established church is to assert an authority on the part of the federal government to intrude on religious practice in a pretty severe way. Waite goes on to point out that aside from the religious issue, polygamy has simply been disfavored historically. Now, what's this argument for? Well, it's that tradition of our peoples thing again. In the past, we've seen invocations of traditions of our peoples to define things like right to trial by jury. Here, it's being used in an interesting way. Here, it's being used to say that a minority religious practice might not deserve protection because it is traditionally disfavored. Polygamy has always been odious among the northern and western nations of Europe. There's a whole lecture to be given on that phrase, northern and western nations of Europe, but we don't have time. And until the establishment of the Mormon Church was almost exclusively a feature of the life of Asiatic and of African people. So the Mormons aren't quite perfectly white, whatever. At common law, the second marriage was always void. We think it may safely be said there's never been a time in any state of the Union when polygamy has not been an offense against society. The traditions of our people is that police powers of the states extend to banning polygamy, which doesn't get us to federal power yet. But right, the traditions of our people define police powers, plessy, the customs and understandings. Second, it is clear, says Waite, that on questions of marriage, specifically, we're talking about a civil contract. This is a matter for civil authorities. This is not a religious thing at all. In the face of all this evidence, it is impossible to believe that the constitutional guarantee of religious freedom was intended to prohibit legislation in respect to this most important feature of social life. Marriage, while by its nature a sacred obligation, is nevertheless in most civilized nature a civil contract and regulated by law. Interesting point, in Massachusetts, in the first 4 decades of settlement, the Puritans outlawed the performance of marriages in churches. It was considered a mixture of religion. It's a civil relationship bound by law. And to let the churches get involved in it would violate the Massachusetts Puritans' version of separation of church and state, which is different and complicated, but they had one. A version. I'm not trying to extol it as a model for modern governance. Professor Lieber, that's Francis Lieber. He's a very important legal theorist and writer in the period. So this is like saying, I don't know, this is quoting some big authority on history. Professor Lieber says polygamy leads to patriarchal principles, which when applied to large communities fetters the people in stationary despotism, while that principle cannot long exist in connection with monogamy. So monogamy is not only traditionally disfavored, contrary to our traditions, and flip that around. It is consistent with our traditions to have laws against it, that whole police powers kind of way of thinking. Secondly, philosophically, it makes people unfree, specifically women. It imposes patriarchy. Monogamy is a state of freedom and equality. Polygamy is a state of enslavement. We must protect women against this odious practice. He used the word, odious practice. And then again, there is no right of religious exemption. Saying that it's motivated by your religion or your religious beliefs does nothing to establish that your behavior can't be regulated by civil authorities. Laws are made for the government of actions. While they cannot interfere with mere religious beliefs and opinions, they may with practice. And he gives the usual kind of slippery slope parade of horrible cases. Supposing one believed that human sacrifices were a necessary part of religious worship, or if a wife clearly there's a typo here, my apologies. I believe it should say if a wife religiously believed it was her duty to burn herself upon the funeral pyre of her dead husband. That's sati, the Hindu practice. Would it be beyond the power of the civil government to prevent her carrying her belief into practice? Right? So you can't say, just because something is religiously motivated, it's entitled to an exemption. That would open the door to all kinds of horrible practices. And it's very easy for us to make up other horrible practices, right? My religion says, one of every 3 children must be staked out to die and eaten by wolves. Well, you can't do that. I'm going to pause here before I go. That's it for this case. 9-0, no dissent. This wasn't controversial. There wasn't any question about it. There was no way they were going to allow Utah to enter as a state and legally permit the practice of polygamy. That was just not going to happen. Question for y'all. It's very easy to say, well, you wouldn't want to have a religious justification for murder, right? Does that mean, as Waite suggests that it does, that there's never a good religious reason for exemption from anything? Or do we need some as yet not seen, as yet not introduced, different way of reasoning about the question that would allow us to distinguish among cases? Does everybody understand the point that I'm raising? Regardless of where you'd come on the polygamy question. Second question for y'all. If this issue arose today, and it might one of these days, who knows? If the Supreme Court were to be consistent, which it is not always, to put it mildly, but if the Supreme Court were to be consistent, would they have to accept the legality of polygamy? I'll be even more pointed than that. Does recognition in Obergefell of a right to same-sex marriage logically lead to a right to polygamous marriage? If so, how? If not, why not? What's your distinguishing principle? We would need, in order to answer that question either way, yes or no, you would need a set of reasoning tools that we have not yet seen. All right, next case. Meyer versus Nebraska. This one's a state case. It's about substantive due process, not 1791 rights and not incorporation. It's about non-economic rights. And the obvious question is, where do these rights come from? The particular right here is the right of parents to send their children to a school whose classes are conducted in German. Nebraska passed a law saying schooling can only take place in English. And that was challenged. By 7-2, so not 9-0, but still, it's a very, very solid majority. Right, so the same, well, it's not the same court, it's 1923, it's 50 years later. Other than that, 46 years later. By 7-2, this court is going to say Nebraska can't do that. The U.S. Constitution, substantive due process, the Lochner idea, right? Or at least some variation on that theme, means that the state of Nebraska cannot say all children must be educated in English. Now, obvious background, but it's easy to lose sight of, okay? It's 1923. There's no television, there's no internet, obviously no internet. People who live in rural areas often don't travel very far It's very often the case that the people whom they know for most of their lives are people who are within a 20-mile radius of where they were born. To this day, I was in a place in Kansas a few years ago, and I was talking to a young couple that picked me up at the airport and driving me to a thing I was doing. And they were both from Kansas, from that town in Kansas. Their 4 parents were all from Kansas. Their grandparents were all from Kansas. I didn't get as far as great-grandparents, but the young man who was driving the car said he'd been outside of Kansas once. He'd gone on a trip to Washington, D.C., and I said, well, how was that? And he said, it was all right. Which I thought was a fair assessment, right? But it is, I think, difficult for those of us who don't come from this particular kind of background, which was, of course, much, much more widespread in 1923, to realize how insular communities can be. Why am I saying all this? Because in Nebraska at this time, there was a very large German immigrant population who spoke German, read German, had German newspapers, and in many cases didn't speak English. To this day, in cities like China, like San Francisco and New York, there are Chinatowns where you have 3rd and 4th generation people who don't speak English. So Nebraska responds to, well, this won't do. And of course, you've heard people say, you've heard the arguments. There should be a national language, it should be English, everyone should learn English. You've heard this, right? I'm not saying if you agree with it, you've heard it. I'm just trying to suggest that in 1923, that wasn't quite so obviously an exclusionary position as it is today. It was at least somewhat more plausible. At least that's my view. As always, you can disagree. Yeah? Blah, 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 blah. You mean Native American Indian? Yeah. So the reason we're not covering Indian law cases in this class is it's a whole unique situation. The Indian tribes that were recognized by the federal government are treated as foreign nations. Indian reservations aren't part of the United States for purposes of constitutional rights. This was sold in a case called McNaughton in 1890. I don't remember. I'm sorry. Maybe earlier than that. Might be 1790. Look up. There's no C. M apostrophe Naughton. No. I promise you. Oh, you're thinking of the Monotone test for intent. Yeah, different. This was sold as, this is a wonderful gift we're giving to Indians. You're separate nations, therefore you can have your own laws. It also meant you have no constitutional rights protections whatsoever. Short answer. The real answer is longer and even more depressing. Also, this is just a state law in Nebraska, don't forget. There's no obligation for Oklahoma to have a law like that. So, all right, Nebraska's trying to say you can only you can only have your kids go to, your children must be, damn. I really wanted a cup of coffee coming in on here, and I clearly should have gotten one. Nebraska passes a law that says children must be educated in schools that teach in English. This is struck down. Why? Substantive due process. What is this substantive due process thing, this liberty? So far, we've seen it only as liberty of contract, right? That's the only version that we've seen. While this court has not attempted to define with exactness the liberty guaranteed by the Due Process Clause, again, right? There are fundamental rights, we won't list them. There are police powers, we won't list them. There are some sort of liberties with some sort of elements in the substantive due process, but we're not going to list them. The term has received much consideration. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual, and now listen to this list of stuff. To contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, bring up children, worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. What is that? Now, for one thing, it's not very far off from Field's description of the rights of freemen in his Descent and Slaughterhouse. Right? So you can think of this as Field's revenge. But it's more than that. I mean, there's an odd outlier to worship God according to conscience. That one's in the First Amendment. So why is it substantive due process? I mean, arguably because the First Amendment doesn't yet apply to the states. Fine. Okay. Right? But it's in a little bit of a different status than these others. This is a description of the fundamental liberal idea of a public-private divide. This is the first appearance of what's going to become the right to privacy. There are areas of life in which the government may not intrude. To be free is to have self-control in these areas. And the meaning of the word liberty is that there are places, to borrow a phrase from Mario Matsuda, there are places where the state may not go. That's a huge idea. It's philosophically not a brand new idea at all. There's a version of it in Pericles' funeral oration in Thucydides. But as an element of the American constitutional law, this really comes out of nowhere. And the question is, what's its basis? That's my question. Their answer is the word liberty in the Due Process Clause. Just like it meant bakers couldn't be subject to regulation about how many hours they could work, it also means you can't have laws limiting making contracts, engaging in common occupations of life, acquiring useful knowledge, marrying, establishing a home, bringing up children, and so on and so on. All the sort of private activities that are subject to private law kinds of contracts are outside the reach of the state, according to this rather broad statement. What does that have to do with this particular, how does it apply to this particular case? Part of it, and see if this doesn't resonate with some of the debates you're seeing in the news these days, has to do with parents' undoubted right to control the way their children are educated. You know the line from Faulkner, right? In America, the past isn't dead, it isn't even past. The American people have always regarded, it's just always been true. It's a throwaway line. What's the source? It's just always been that way. And education and acquisition of knowledge as matters of supreme importance, corresponding to the right of control, it is the natural duty of parents to give his children education suitable to their station in life. And nearly all the states, including Nebraska, enforce this obligation by compulsory laws. Right? So it's okay for Nebraska to say, have compulsory education laws. It's okay to say you must make sure your children are educated. Why? Because that's the natural duty of parents. But it's not okay for Nebraska to tell you how you must educate your children. Right? We can say you must carry out your private duties, but we can't interfere with them. Enter what's going to become very familiar as substantive due process analysis, the ends and means test. You have to ask, what is the end, the purpose the state is pursuing? And what is the means by which it is doing it? And a law can be invalid on either ground. In Plessy, we already saw, right? A law could be invalid if it pursues an invalid end, the oppression or annoyance of a particular class. Recall? And we're also going to see here for the first time that even if the end is legitimate, the means may be inappropriate. Now remember, a couple of times now in both state and federal contexts, we've seen that McCulloch language. Let the end be legitimate, and any means which is plainly adapted to it is, remember last time we saw that? And we saw it goes back to McCulloch? Not anymore. Now we're going to have judicial tests for those means. And the way the courts are going to test the means that are chosen by the states. Right, so first question, do you have a legitimate purpose? Assume that you do. If you lose on that, you're just done. Just no good. The law is not constitutional. If you do have a legitimate purpose, what was your choice of means? And there are two different questions they're going to ask. One, is your choice of means something that violates constitutional rights? I may have a legitimate interest in preventing car accidents. That does not mean I can confiscate every car in the city without paying compensation. Not the best example, but right, you get it. But there's a second way in which the means can be improper, which is much more interesting. When a state, remember we're talking about states exercising police powers. We're not talking about Congress here. When a state makes a law for a good legitimate purpose, public safety, something clearly within police powers, clearly legitimate, no issue there, right? And it uses to do this, it creates a law that does not violate constitutional rights. Not like the one I just made up. All right, so none of that. The law may still be unconstitutional. If the means are not, well, remember the term in 13.2 and 14.5, appropriate legislation? Here the term is reasonably related. The idea that the authority to adopt appropriate legislation is a limitation is now applied to the states. In pretty much the same way we've seen it previously applied to Congress under 14.5 and 13.2. It applies on the 15th as well, but we haven't dug into that. So, ends and means, right? First, the end. It is said the purpose of legislation was to promote civic development by inhibiting training and education of the immature in foreign tongues and ideals before they can learn English. It is also affirmed the foreign-born population is very large, that certain communities commonly use foreign words. So Nebraska is saying, look, we have a legitimate reason, we want citizens. This is part of being a good citizen. It's a serious issue. There's a lot of people who fit this description. Our state interest is significant. This is a valid purpose. Notice that phrase, it is said the purpose. Could be a pretext. Could be not in good faith. Remember the phrase good faith? Any law that is valid under Plessy, to be valid must be enacted in good faith for the promotion of the common good. Well, okay, fine. They're willing to acknowledge that this purpose might be legitimate. But the means are a problem. That the state may do much, go very far indeed, in order to improve the quality of its citizens, physically, mentally, and morally, is clear. But the individual has certain fundamental rights. Perhaps it would be highly advantageous if all had ready understanding of our ordinary speech. But this cannot be coerced by methods which conflict with the Constitution. So two things. One, I've already said this, but the analysis of means is entirely separate from the analysis of ends. The fact that the state had a legitimate purpose does not end the question. There's an independent inquiry about the means. Second, one way the means can be invalid is if they violate constitutional rights. But you can also, as I said before, have means that are simply not sufficiently related to legitimate ends to be justified. Mere abuse incident to an occupation, ordinary useful is not enough to justify its abolition, right? The fact that there might be abuse in teaching German, perhaps it's being done in a way that prevents kids from learning English, that would be the abuse here. We're not talking about child abuse, we're talking about just bad practices of which we disapprove. Is not enough to justify banning it. No emergency has arisen. So first, emergency might make a difference, which renders knowledge by a child of some language other than English so clearly harmful as to justify its inhibition. We are constrained to conclude that the statute as applied is arbitrary. Remember that arbitrariness idea? Now it's being much more focused. Arbitrariness turns out to be a test for means. A law is arbitrary if the means that it employs to pursue a legitimate end are not sufficiently, and filling in sufficiently is clearly a problem, right? But not sufficiently shown to be appropriate. And without reasonable relation to any end within the competency of the state. So for the first time, we have a formulated test. In Lochner, we were told all laws must be reasonable. Remember? Now we've got a much more spelled out version. There's an ends test and a means test. The ends have to be legitimate, and the means have to be reasonably related to that legitimate end. And if they're not, they're unconstitutional. And all of that comes from the Due Process Clause. Furthermore, if the means chosen infringe on the pursuit of ordinary occupation or the acquisition of knowledge or marrying or raising the private life area of stuff, then the law is unconstitutional because the means are a violation of constitutional rights. This is conceptually at least, a potentially huge and sweeping restriction on what up until now I have been hammering into you, right, is traditional police powers, which emphatically included all of these things and many more besides, historically. All right. Holmes dissents, which shouldn't shock you, considering his Lochner dissent. He says, I cannot bring my mind, to believe that in some circumstances, and circumstances existing, it is said in Nebraska, the statute might not be regarded as reasonable. So first of all, same thing he did in Lochner. I'm not going to ask, is this reasonable? I'm going to ask, could somebody think this was reasonable? This is a much more deferential way of reviewing the question. And he goes through a discussion of why we care, how children are educated, youth is the time when familiarity with the language is established, if there are sections of the state where a child would hear only Polish or French or German spoken at home. I am not prepared to say that it is unreasonable. He's not saying it's reasonable, he's just saying as a judge he's not in a position to declare that it's unreasonable. To provide his early years he shall hear and speak only English at school. All right, so at least it could be reasonable, right? Well, says Holmes, if it could be reasonable, that means it's constitutional. Because if it could be reasonable, then we're obliged to accept that it is reasonable within the scope of discretion of legislatures. Same thing that he said in Lochner. If it is reasonable, then it's constitutional. If it is reasonable, it is not undue restriction of the liberty of either teacher or scholar. No one would doubt that a teacher might be forbidden to teach many things. Right? There's no theory that says teachers in schools can teach whatever they want. The curriculum is set by the community, a school board or a state school superintendent, by whatever system of educational governance you happen to have. And the only criterion of his liberty under the Constitution that I can think of is whether, considering the end in view, the statute passes the bounds of reason and assumes the character of a purely arbitrary fiat. This appears to me to present a question upon which men might reasonably differ. Unless the means chosen are unrelated to the purpose. How could you have well, we'll come back to this question later. Unless the means that are conducted are unrelated to the purpose, arbitrary in that sense. I really want to improve public health, therefore no one is allowed to wear the color blue. Huh? Right? That's arbitrary. Unless it's like that, says Holmes, we have no business using this new theory of substantive due process to strike it down. All right. Pierce versus Society of Sisters. Again about teaching in schools and students. This time it's a freedom of religion question. By the way, it's really interesting. Today, there's a kind of an intellectual movement among religious conservatives to argue that Meyer was actually a religious freedom case, which is weird because there's nothing religious in the case at all. It's about teaching in German. It wasn't a religious school. These weren't religious parents. There wasn't a claim of religious freedom. They weren't motivated by religious belief. Pierce, however, does involve religion. And so the attempt is to argue that this early appearance of a substantive due process right of privacy or of private life or an area where the state may not go is actually just a religious prerogative. But go back and look. There is literally not a word of that in the opinion, in the arguments that were made, and the positions that were taken. But Pierce is more complicated because Oregon had a law that said you can only have public schools. Meaning you can't have private schools, meaning you can't have religious schools. The purpose was to shut down Catholic schools. It was very, very well recognized by everyone at the time what was going on and what was the goal. Now, the question I put in the notes here, and it's a question we can only try to answer in retrospect from many, many years later. Is this a freedom of religion case? Is this a parental substantive due process case? Or is this a case about a right to education? You can present it any of those ways, right? You can say parents get to choose how to educate their children. And if they want to educate them in a Catholic school, they can do that. If they want to educate them in German, they can do that. If they want to educate them hanging by their feet, they can do that. It's up to parents, as long as they make sure their children are educated. Or you could say it's a religious freedom case. The exercise of religion requires sending your children to a school in which they'll be taught the tenets of your religion. It needs to be all day, not just during church attendance or something. It has to be something they're immersed in all the time. Therefore, right, as a matter of religious practice, you must be. You could argue it any of those ways. Which way did they? And I actually, so McReynolds writes the opinion. McReynolds is one of the four horsemen, one of the arch conservatives, one of the ones who strikes down laws hither and yon. So here he's being consistent that way, but this is not an economic case, right? At all. And again, it's 9-0. And what's really interesting is that he presents this as a case about property rights. Because Society of Sisters, the party in the case, was the name of the group who operated the school. And they didn't say their religion was being trampled on. They said they were being driven out of business. The manifold purpose is to compel general attendance at public schools. Without doubt, enforcement of the statute would severely impair, perhaps destroy, the profitable features of FLE's business and greatly diminish the value of their property. So, this could be a parental rights case, this could be a religious freedom case. Let's treat it as a property case. That's a much more comfortable place to be, isn't it? Well, let's describe the business. It has long devoted its property and effort to the secular and religious education and care of children. In a primary school, skipping a couple of lines here, many children between these ages are taught the subjects usually pursued in the Oregon public schools during the first 8 years. Systematic religious instruction and moral training, according to the tenets of the Roman Catholic Church, are also regularly provided. What's the point? This satisfies the obligation. Remember, we just said it's okay in Meyer for states to require that children be educated, to require parents to carry out their duty of making sure their children receive education. But that's happening here. But this is not an abdication of that parental responsibility. The secular topics are being taught. So this is not a matter of a state insisting that everyone be educated to a certain degree of proficiency in secular topics. That would be fine. This is an interference in what else you can teach along the way, or if you prefer, this is an issue about whether the state can interfere in how you choose to fulfill that parental duty, which puts it square in the area of Meyer. It's a parental rights case and a substantive due process case. Listen to this next paragraph and listen to the rights that are at issue. After setting out the facts of the society's bill, that is the pleading in the court that the schools have filed, the enactment conflicts with, 1, the rights of parents to choose schools where their children will receive appropriate mental education. 2, the right of the child to influence the parent's choice of a school. I love that one. Children have a right to try and persuade their parents to send them to the school they want to go to. I just find that charming. Remember, a constitutional right. We're not talking about a philosophical right. 3, the rights of schools and teachers therein to engage in a useful business or profession. So it's all of them. It's property rights and it's parental rights. We haven't heard any reference to religious freedom yet, but we will. Actually, I'm not sure that we will. But there's clearly at least a potential dimension of that because it's a religious school issue. Well, what about the whole police powers thing, right? What about that states have these authority? What's the limiting principle that says here they've gone too far? No question is raised concerning the power of the state reasonably, there's that word, to regulate all schools. Right? So back up. We were told in Meyer, we're told here again, states have a legitimate authority to exercise their power to ensure all children receive education in secular subjects. Check. States may choose means to achieve that end. Check. The means must be reasonable. If the means are not reasonable, that will violate the Constitution. No question is raised concerning the power of the state reasonably to regulate all schools, to inspect and supervise their teachers and pupils, to require that all children of proper age attend some school, that teachers shall be of good moral character and patriotic disposition. I think I would pass that test. I'd pass one of them anyway. Either the good moral character. That certain... Yeah, there you go. That certain studies plainly essential to good citizenship must be taught, civic education, curriculum, and that nothing be taught which is manifestly inimical to the public welfare. So, a little more. The states can do more than just require that everyone be educated in secular subjects. They actually can ban teaching certain other things, those that are inimical to the public welfare. In 1925, that would be communism, let's say, or anarchism, or something. But in general, the point is, Meyer had this very, very broad statement of the freedom of determining the mode of education. Actually, this case kind of pulls back a little bit, gives the states a little more authority, and makes the right a little narrower than the version we saw in Meyer. But here, that's not an issue because instruction in the Roman Catholic faith is not a harmful activity. These parties are engaged in a kind of undertaking not inherently harmful, but long regarded as useful and meritorious. Right, so remember in Meyer, the mere abuse of an educational practice is not enough to justify banning it. Same thing here. Sure, maybe somewhere there's a religious school that's doing something bad. But the mere fact that that's possible, the mere fact that is not enough to justify the state in banning religious schools from operating. Perfectly okay to require teaching secular subjects, perfectly okay to require certification of teachers on various grounds of both qualification and character. All that's all good, that's all fine, but you can't shut them down. How do we know? Meyer. Under the doctrine of Meyer versus Nebraska. We think it entirely plain that the act unreasonably interferes with the liberty of parents and guardians directing the upbringing and education of children under their control. And notice what's remarkable here, there is no religious freedom argument. Now, there almost can't be. Why not? Reynolds. We just finished saying, well, we just finished saying, it's 1878, but the Supreme Court has said it is within the scope of the federal authority to regulate marriage. If you can regulate who can marry each other, you can probably regulate how you educate children. There is not available a religious freedom vocabulary to assert an argument here. In fact, just so you know, and we'll get to this, the religion clauses of the First Amendment are not applied to the states until the 1940s. So this is not a visionary, rejection of Reynolds. This is purely substantive due process argued in terms of the reasonableness required of the exercise of police powers. The fundamental theory of liberty, as often heretofore pointed out, rights guaranteed by the Constitution may not be abridged by legislation which has no reasonable relation to some purpose within the competency of the state. The fundamental theory of liberty, there's that word, upon which all governments in the Union repose, that is, all the different states, excludes any general power of the state to standardize its children. Now, this is new. What does this one mean? So, substantive due process means you can't interfere with a variety of private decisions, pursuing the ordinary occupations of life, whom to marry, right? The stuff that was described in Meyer. It also means that while on the one hand we recognize an interest in this on the part of the state, in making sure everyone's a good citizen, in making sure everyone has certain shared knowledge, in making sure lots of things, it cannot extend so far as to, quote, standardize them. By forcing them to accept instruction from public teachers only. Why? The child is not the mere creature of the state. Those of you who have had intro to political theory will recognize this is a stark declaration of liberal principles against Republican principles. It's a stark declaration of a sphere of private life that is not the state's business. Those who nurture him and direct his destiny have the right coupled with a high duty to recognize and prepare him for additional obligation. All right, that's the end of that one. Let's talk about free speech, a different First Amendment area. But by the way, before we do, look how quickly, look how complicated this got, how quickly. I mean, okay, fine, Lochner was somewhat complicated, but the basic battle lines were pretty clear. Is economic behavioral, is the liberty, freedom to engage in economic behavior, right, without government regulation, is that guaranteed by the Constitution? Yes, it is. This is potentially much bigger, much more sweeping, which is probably why we won't hear this theory again until the 1970s. Not stated this strongly. And what is, by the way, one of the most well-known and controversial rights that's involved in this idea of a private sphere where the state may not go? That's abortion. All right, free speech. We'll come back to privacy and all of its implications and whether it involves parental rights and whatnot. We will come back to all those, I promise. Free speech should be so much simpler. It's so much easier, right? Oh, you're not going to fall for this, are you, anymore? You've gotten way too clever for these games. All right, fine. So we start with a federal case. Freedom of speech is, of course, one of the 1791 rights contained in the First Amendment. So Schenck versus United States, that's how you can tell it's a federal case. It's 1919. I mentioned in an earlier lecture, the italicized paragraph gives you some background. I don't want to waste time going through it, but I mentioned in an earlier lecture that the period, the 20 years or so before World War I, is a period where there's a great fear of anarchism and syndicalism and socialism and other foreign ideas coming in. It's a period of lots and lots of laws passed to try and stamp out organized labor, which is viewed as an expression of those things, and there's all kinds of reasons of connections and so on. Come World War I, it becomes much more serious. These become the anti-sedition laws, the first really widespread anti-sedition laws since all the way back in the early 1800s. As is noted here, thousands of people go to prison, many thousands more are deported. There are both state and federal laws involved. I love the background of this story because the two defendants, Charles Schenck and Elizabeth Baer, are standing at train stations handing out leaflets during World War I saying that the draft violates the 13th Amendment. Does it? Let me rephrase this. Are you 100% sure it doesn't? The 13th Amendment doesn't say no involuntary servitude except if there's a really urgent national need. It says no involuntary servitude except as punishment for a crime. Is responding to a military draft a voluntary choice? Well, what happens if you don't respond? You go to jail. That's not the usual definition. So, I mean, it's not an insane, it's not an insane position. It's insane in the sense that if that's what the 13th Amendment meant, we'd have to change it because you can't operate that way, right? But it's not analytically insane. Almost more interesting, they're making a constitutional law argument. how can it be criminal sedition to make a constitutional law argument? I mean, our very first free speech case is about as core as a free speech case could possibly get. What could possibly be more absolutely central to any conception of freedom of speech than the freedom to talk about the meaning of the freedom of speech? I'm not sure I'm selling this, but I hope you'll see at least why I find this it's almost extraordinary what a powerful exemplar case we happen to start out with. And what's the answer? 9-0, sorry, you lose. Holmes says, send them to jail. Why? Well, we got to figure out, but I mean, okay, I see someone shaking their head. I think most people nowadays disapprove of this outcome, but what's the logic? That's what we care about, right? Holmes starts by talking about intent, and he makes an analogy. In every crime, or with respect to every crime, there's an act that is criminal. Murder, theft, arson, whatever is the crime, right? Okay, for every crime, it is also a crime to attempt that crime. If murder is a crime, attempted murder is a crime. If arson is a crime, attempted arson is a crime. There's a lesser included offense of the attempt involved in the crime. Got it? It's not very complicated. It's right. Okay. Well, Holmes says that's how you should think about speech. If the speech is intended to produce a criminal outcome, then the speech is itself criminal. It's an attempt. Of course, the document would not have been sent unless it was intended to have some effect. We do not see what effect it could be expected to have upon persons subject to the draft, except to influence them to obstruct the carrying of it out. So if evading the draft is a crime, then telling someone, hey, you should evade the draft, is a crime, because it's like the attempt that attaches to the act. Well, what about the First Amendment freedom of speech? Oh, says Holmes, it all depends on circumstances. This is it. This is the fire in a crowded theater. It is said, suppose that was the tendency of the circular, it is protected by the First Amendment. We admit that in many places and in ordinary times, notice the emphasis on circumstances. In many places and ordinary times, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech will not protect a man in falsely shouting fire in a theater and causing a panic. I'll come back to that. I've already told you I think it's one of the worst analogies in the history of constitutional law, but I'll come back to it in a second. The question in every case is whether the words used in such circumstances and are of such a nature. So two things, circumstances and content. What's the nature of the words and what's the circumstances? To create a clear and present danger. And this is the clear and present danger test. So the famous clear and present danger test actually has two parts, or two elements, let's say. You ask, what's the content of the words? And you also ask, what are the circumstances? And they're both valid things to think about. Falsely shouting fire in a crowded theater and causing a panic. If there really were a fire, would that be protected? If it was false, but it didn't cause a panic, would it be protected? If it was false and it caused a panic, but it weren't in a theater or something like a theater, right, an enclosed space with crowded people and limited exits, would it be protected? How do these elements relate to each other? We have no idea. What's even more interesting is that Holmes seems to think that the case is so obvious there's no need to explain it. Of course there's no constitutional right to shout fire in a crowded theater. Really? I mean, maybe. So, returning to his original point and his formulation of the clear and present danger test then, you have to ask, under the circumstances, is there a clear and present danger that if this speech were effective, right, that's that attempt idea, it would produce a criminal outcome. It seems to be admitted that if an actual obstruction of the recruiting service were proved, liability for words that produce the effect might be enforced. Well, if the act, its tendency, and the intent with which it is done are the same, we see no ground for saying success alone warrants making such an act a crime. Now, here's what's interesting. Holmes presents the clear and present danger test as an increased protection for free speech. Because the older test from a British case called Regina versus Hickland, Regina just means queen, was what's called the bad tendency test. In the common law tradition, it was perfectly okay to punish people for expression that had a bad tendency. That's it. Might lead to disorder, might lead to immoral conduct, might lead to bad thoughts, just a bad tendency. Holmes presents this argument as though he's creating greater, what is greater, protections for free speech. Nah, he says, you can't say that. If the circumstances are such that there's no risk, if the circumstances are benign, right, or the content is benign, then we shouldn't punish it. But of course, he takes it for granted that if you have the right combination of circumstances and content, excuse me, it's perfectly fine to punish that. That's the more protective theory than the one that it's replacing. With me? Okay. Now it gets a little complicated, because now we have incorporation. Does the freedom of speech apply to the states? And for the first time in American history, in 1925, the Supreme Court says, yes. Why? Because of the Due Process Clause of the 14th Amendment. Now look, doesn't this obviously belong in the Privileges and Immunities Clause? Remember the thought experiment I said if I gave you 3 note cards and one had the Privileges and Immunities Clause and one had the... I think, and no one seems outraged, I think you'd say, oh yeah, privileges and immunities, that's about rights. No state may infringe on the privileges and immunities of citizens of the United States. That sounds like a rights guarantee. And you'd ask, does that include free speech? And you'd probably say, yes, privileges and immunities of citizens, right? That's probably, so why are we doing this? Let us not disguise the fact, weird intellectual exercise to try and cram this into the Due Process Clause. Why not just go back and overrule Slaughterhouse? To this day, we've never gone back and overruled Slaughterhouse. Why? The best answer I know, I don't have a good answer. There have occasionally been, Justice Thomas has come pretty close to saying we should overrule Slaughterhouse, get rid of all of the century and a half we have of due process jurisprudence and start over. Because it's all built on a confusion. And he's not wrong in the sense that it's built on a confusion. He's a little nuts in the sense that the chaos that would result would be, pretty intense, right? Justice Scalia, referring to his friend Clarence Thomas, once said, I'm an originalist, but I'm not a nut. But he's not wrong that it's very hard, I think, to explain why, if we want, let's reason backwards. Let us reason backwards together. Let us assume that we all agree that states should be bound by the First Amendment's free speech clause. Is that fair? Right? I mean, I feel very strongly about this myself, and I think we may disagree about its precise meaning or its limits. We may disagree about lots of things, but as a general principle. Great. So reasoning backwards, let us now find a place to find that when we go to the Privileges and Immunities Clause. The best answer I know for why Slaughterhouse has never been overruled is if you look at Field's opinion, his dissenting opinion, that every American is entitled to the rights that attach to being freemen or free people, it's scary. The range of constitutional rights that would be guaranteed are vastly broader than anything any of our courts have ever entertained. The role for courts in reviewing and striking down laws would be what Madison talked about in the Virginia plan. Right? Madison thought there should be a council of review to review every state law and strike it down if they thought it was unwise. It would look like that. If you read the Privileges and Immunities Clause to mean what the words sound like they're saying they mean, it's a brand new constitution. You're starting over from scratch. You have to start over and write the rights from the beginning. And frankly, nobody wanted to do that. Nobody wanted to disrupt federalism. Nobody was willing to let go of state sovereignty. That was part of the argument. No one wanted to be in the politically risky position as a court. And to this day, no court's ever wanted to be of naming and affirming all the rights that are required to make people genuinely free and equal. It's just too big. Slaughterhouse, if you go back and think about Miller's opinion, what did he say? He said, if we read this thing the way my colleague Field suggests, it means we've dramatically changed the basic structure of federal-state relations and citizenship, and that can't be right. That was it, right? Can't be right. Exactly. But on the other hand, to not have a right of free speech that applies to the states would be intolerable. So Gitlow's the case, 1925. I'm running out of time, and that's fine. You've probably heard about this case before in some other class. It's very, very easy to read. It's very simple. Really fast, though, let me point out 2 quick things about it. So a socialist member of the New York State Assembly is sent to prison. The Supreme Court says that for publishing a pamphlet that says the day will come when there will be a revolution and the United States will be overthrown. The majority says that's incitement, that's advocacy. That's not just a scholarly description. That's actually calling for something, approvingly. And if you call approvingly for violence and lawlessness, we can put you in prison. And he uses basically the bad tendency test. Holmes writes a dissent in which he tries to urge the court to adopt his clear and present danger test. But as you saw in Shank, that's not all that protective either. There's one passage that I would like to call to your attention. Well, a couple. So first of all, on page 8 of the notes, you see under C, this very short statement is where incorporation happens, and it happens almost without any explanation. For present purposes, what does that clause mean? Not in future cases? For present purposes, we may and do assume the freedom of speech and of the press, which are protected by the First Amendment, from abridgment by Congress, are among the fundamental personal rights and liberties, right, so that word liberty, protected by the Due Process Clause of the 14th Amendment. That's it. That's the entire analysis. Second, he goes through a discussion of state police powers and the need to defer to legislative judgment. Look on page 9 of the notes, number 4. The state has determined through its legislative body that utterances advocating the overthrow of organized government by force are so inimical to the general welfare and involve such dangers of substantive evil they may be penalized. Every presumption is to be indulged in favor of the constitutionality of a statute. This is the opposite of Lochner. In Lochner, the burden was on the state to show its law was reasonable. If the justices weren't persuaded, that's it, it's unconstitutional. Where speech is concerned, we're much less protective. We're going to assume the law is constitutional unless you can prove to us that it's not. We will defer. That's why deference is such a tremendously powerful concept. It determines which way the burden of proof and persuasion goes. It determines what you start out assuming to be true and what then has to be proved. Finally, look at number 5. There's no requirement. So remember, Holmes says clear and present danger, right? Circumstances. No, says the majority in Gitlow. The immediate danger is nonetheless real and substantial because the effect of a given utterance cannot be accurately foreseen. Right? You don't know what it's going to actually do. The state cannot be reasonably be required to measure the danger from every such utterance in the nice balance of a jeweler's scale. A single revolutionary spark may kindle a fire that, smoldering for a time, may burst into a sweeping and destructive conflagration. So the state has to have the power to punish and thus prevent speech that might someday lead to violence and lawlessness. And Holmes is outraged, but remember, Holmes is the one who said that speech which is intended to produce an effective action is like an attempt of a crime. So do not make the mistake as you look at these notes of thinking that Holmes is some kind of free speech libertarian. These guys are arguing our positions on a spectrum of possibility that are not that far apart at this time. That is going to change as we go forward. That's your first introduction to the First Amendment, freedom of religion and freedom of speech. Things to remember are, of course, those particular things, but more generally, 1791 rights, incorporation, and substantive due process. Got it? Excellent. And now we're really into some rights, right? Now it's the good stuff. Garrett, do not leave. I must talk to you.